Thank you so much for joining us. This week, we're going to be focusing on business litigation and all the pitfalls and stuff to prepare for as we go through what to expect. Today's focus is going to be understanding litigation, its impact on businesses, and we're going to attempt to break down the complexities into clear and actionable insights. So your host today is yours truly, and my name is Charles Miller. I'm a senior associate, and I'm here on behalf of Achkar Law. Achkar Law is your litigation partner. We are a leading firm offering litigation services for businesses all across Ontario. But our approach is we provide cost-effective solutions to resolve business disputes. We're a firm that is very much experienced in all aspects of litigation and business litigation, knowing exactly how to guide your business through it and how to avoid it to the best of your ability. Our services focus on civil and commercial litigation. We do contract disputes, shareholder disputes, partner disagreements, intellectual property issues, and much more. As to why you should go with us, well, our team is dedicated to achieving the best outcome for clients through negotiation, mediations, as well as experienced corporate presentation. Why does litigation matter? Specifically, why does business litigation matter? For many of you, as business leaders and business directors and owners, you're focused on creating business and creating a new product and delivering service within the industry. Often, you're so focused on making the economy go and your business grow, develop that litigation is something of an afterthought, something that really only comes up if it comes up. But litigation is something that businesses should actually have their finger to the pulse on. There's many reasons why. First and foremost, the financial impact. Making sure that you are prepared or ready for litigation or business litigation, you can help you avoid costly legal battles, not just paying your lawyer, but the actual disruption to your business. Because often if a litigation comes your way, your directors, your managers all have to redirect their energy away from the business to actually dealing with the matter. You also want to focus on protecting your business reputation. As all of you know, your reputation is crucial to how successful your business is in the industry. So if you have disputes with clients, disputes with partners, or forbid a actual active legal claim against you, it can hurt your business reputation and therefore harm your business, period. Well, another reason why litigation matters is compliance. It's not just clients and employees and partners who can raise concerns. The government themselves might take issue with your business if you're failing to follow compliance and policies and legislation. Ensuring everything is in place is very important. This is why litigation matters. As a business owner, there are certain types of disputes that will be the regular culprits that come across your desk. The first one being contract disputes. These are breach of contracts, such as clients accusing you of failing to deliver a service or a good, or breaching the timeline of service. You might even see former employees saying that you breached their employment agreement. These can come up if you have unclear or ambiguous terms within your employment agreement, such that it's not clear how to navigate these types of disputes. Even being accused of a breach of contract might not even be legitimate or fair, but if your contract has ambiguous or unclear terms, your company might find itself liable. Another common culprit is employment law issues. These are terminations, harassment complaints, former employees coming back and saying they weren't paid enough when they were terminated, or active employees saying that they're harassed or discriminated against during the actual employment with your company. Being prepared for dealing with these are very important when you have potential litigations coming across your desk. Another one is intellectual property disputes, having trademarks or copyright concerns, patent infringement. These can be massively disruptive to your business operations. In fact, some of us older folks may remember when the World Wrestling Federation lost a legal dispute against the World Wildlife Fund, a big trademark and copyright dispute, and the World Wildlife Fund won. So then the World Wrestling Federation all of a sudden had to do a complete new marketing overhaul. All their WWF merchandise went to the wind. And now they had to rebrand themselves. For companies, especially for smaller ones, this can be a major hurdle. This can be an extraordinary disruption to your process. So being ready for them, very important. Another common culprit of business disputes are shareholder conflicts. These unfortunately do happen more than we would like them to. These are disagreements between the business owners, the partners, the shareholders. As you all know, as an entrepreneur, as a business owner, you are focused on creating something. You are bringing something out of nothing, creating business within this environment. And sometimes you can have people who you work together at the start who all of a sudden have disagreements of where the company should go, disagreements about dividend payouts, disagreements about the financial structure of the company. Knowing how to navigate these is crucial. Having a shareholder agreement in place or a partnership agreement in place will all be very crucial and helpful. Lacking this, you may find yourself in quite the quagmire of what to do with somebody who has a major stake in the business. Whenever you have one of these disputes come across your desk, there are certain ways to tackle it. The first way you want to tackle it is just straight up negotiation. Often, whenever somebody in a business dispute approaches you, they usually have a solution in mind. They usually want something from you. This isn't a typical dispute you might have with a friend or a romantic partner where they might approach you and say that their feelings have been hurt and it's just enough that they're sharing them with you. Typically in business, when someone approaches you with a dispute or disagreement, they have a solution in mind. That gives you an inroad. That gives you the way forward to know, okay, I can now negotiate a settlement because they want something out of this. They're not just here to complain. Usually they're not just there to complain. And so negotiation is the best way forward. But bear in mind that you want to make sure you know the strengths of your position. Just because somebody approaches you or a client approaches you seeking a discount doesn't mean they deserve one. And in fact, some of the solutions someone might have in mind might be completely unfeasible. So it is a good idea to have a lawyer with you during the negotiation phase of pre-litigation, just so that you can negotiate from a position of strength. The next step, if negotiation doesn't work out, is alternative dispute resolution processes. These are your mediations. These are your arbitrations. These are typically baked within your agreement with your partner, with your employees, or with your clients. We do encourage our employer clients to have arbitration clauses within their agreements. These are because mediation and arbitrations are private, faster, and usually less costly. If you have a clear way forward of, hey, we disagree, we can't seem to negotiate, let's bring in a mediator, a third-party neutral who can talk this out and see things from both sides. If that's not working, we can go through arbitration. Arbitration is actually a binding process, much like litigation, if you actually get a judge to come in and make a decision, though an arbitrator can be private and less costly. You can actually get an answer to that resolution. These are very ideal. However, if negotiation isn't working and ADR, alternative dispute resolution, isn't working, you may end up at litigation. This is typically what we say should be the last resort, and I say this as a litigator myself. You don't want to necessarily lead into litigation first, despite how strong your claim is, or despite how upset you might be with a former friend. Litigation is costly and it's lengthy. The good news is that even if you start litigation or you're defending against litigation, it doesn't mean that you have to stop negotiating. It doesn't mean that ADR processes are no longer available to you. The fact is that a good litigator knows that even if someone's filed a statement of claim against you, there's still room to negotiate. There's still room to resolve. Litigation is just a long road, an expensive road. But a good litigator and a good lawyer knows that there are ways to come forward and resolve this. We're in a situation right now, you're a business owner, and let's say you've got a dispute that's come across your way, a partner that doesn't agree with you anymore, a former director that's left and started a competing business, or an employee who says that there's harassment and want to bring a claim. You've tried negotiating, you've tried ADR, you're now in litigation. What do? Well, if litigation is unavoidable, what we recommend is first gather your documents. Any contract that has to do with the disagreement, any communication that has to do with the disagreement, anything in writing that pertains to whatever arose will be key to building either your claim, if you were looking to bring a claim, or key to your defense if you're actioning a defense against someone. We recommend at this stage, and actually beforehand, hire experienced legal counsel. Choosing a lawyer who has knowledge in litigation is critical at this stage. Many companies and many employers tend to have their own in-house legal counsel that can be useful for a lot of different areas of law. But in-house legal counsel doesn't necessarily mean that they have litigation experience. And having litigation experience is crucial for, you guessed it, litigation. Also, when hiring experienced counsel, it's not enough to just consider, are they a litigator? Do they know the rules of civil procedure? You also want to make sure you hire a lawyer who knows the Ontario Business and Corporations Act, that knows the Partnership Act, that knows your industry. Because a claim brought against, say, someone who falls under the Construction Act is different from a claims that fall under retail or under commercial real estate or under residential real estate. You want to find a lawyer who's not just experienced in litigation, but also knows your industry well so that they know what evidence you need to defend yourself or what evidence you need to action a claim. They know what relevant legislation to be mindful of. This is very crucial. We also suggest, if litigation is avoidable, consider settlement. Again, you've tried negotiation, which usually you consider settlement at that stage. But now that you're in active litigation, you may consider, what are the pros and cons of actually going down this road? Should I actually put forward some money to make the other side go away, or should I forego how much money I'm owed to make sure I don't have to go through the process of active litigation? As I mentioned before, litigation is expensive. It's a long and arduous process. It's not just legal fees. It's the time that you lose with your people having to step away to deal with the matter. Your business owners, your business-minded folk, you have something you need to be focusing on, not litigation. So something a good lawyer will talk to you about, that we would talk to our clients about, is the return of investment at every stage of litigation. What's the next step going to cost? What's a good settlement at this point? It's something to have an active communication with experienced counsel. Another thing to consider as well is actually gathering, preparing your witnesses and the evidence they might bring forward. It's not just your contracts and documents you might have, but people. Ultimately, in litigation, evidence is one thing, documents is one thing, but it has to be people telling the story. So know who's involved in the matter and know which witnesses you may need to prepare and who need to be brought forward to actually give testimony. That's something you can talk to your lawyer about as well. I mentioned before, and I'm going to emphasize it again now, the importance of choosing good legal representation. As a business owner, you don't take half measures with things. Cutting corners, especially in litigation, is just not something you're going to do. So these are things to consider when looking at which lawyer is best for you. So first, look for an industry expert. Find a lawyer who's familiar with your sector. So look at these litigation firms that have active experience with litigation, because again, litigation lawyers are different from your solicitors, different from your wills and estates lawyers, different from even your family lawyers. Fact is that litigators are specialists when it comes to going through the rules and civil procedure, claims to file when they're due, defenses that are needed, evidence that need to be gathered. You need a litigator. And it's ideal to find a litigator who understands your industry. Find someone who's familiar with the area that you work in. They need to be able to tell your story. Litigation is, at the end of the day, storytelling. You've got two people with a disagreement. The customer thinks that they have been hard done by. You, the business owner, think that you've done everything correctly. In fact, you're hard done by. You're telling a story to judge, jury, to an arbitrator, to mediator, and it comes down to who's telling the better story. Well, you want a lawyer who knows your industry, who can talk about why you didn't breach your contract, who can talk about why you didn't breach industry standards, who can talk about things from your point of view so that a third party, a judge, understands completely. They understand where you're coming from. They understand your industry. It's not just the law they have to think about, it's industry standards. What's normal for the way you practice business? These are all very important. You also want to choose a lawyer who has a clear fee structure. I cannot emphasize this enough. Gone are the days where a lawyer shakes your hand and says, don't worry, money will take care of itself. That's not the way things are done anymore. You want a lawyer who presents to you with a clear retainer agreement. They know what your fees, they know what the fee structure is. You know exactly what you're paying for, when you're paying for it. You know, are you paying for hourly work or are you paying on a contingency basis? Are you just paying for the work that's done, or do you give your lawyer a cut whatever they win for you? How much is that cut? Make sure that that's identified at the start. Don't start working right away until you know exactly how you're paying for the service. Last thing you want is to end up paying your lawyer more than you're winning the case. You also want to take a gander making sure you choose a lawyer with a track record of successful negotiations, litigations. This is actually very difficult to identify. Many lawyers might have cases that you can find online. You can see how they've argued. You can see what they presented forward. But some of the best lawyers and litigators don't make it to trial. That is because litigation is not just attending trial. Litigation is pre-litigation negotiations, demand letters, claims, mediations, discoveries for examinations, motions, and then pre-trial trial. There are many stages of litigation, and a good litigator can try to get a settlement before you hit trial. Really good litigators, and especially as a business owner, you want this, know how to make it so that you never reach trial. So to identify a successful negotiation litigator, ask your lawyer consultation. Do they have experience in this area? Do they have experience with cases such as yours? Have they negotiated such a thing? Are they confident in the litigation process? Finding a litigation boutique, or you'll often find the ones who just litigate every day of the week. They know exactly what they're doing. And if you find an experienced firm, they're likely going to have a successful and proven track record in negotiations. That's something to ask in the consultation, something to ask your lawyer about. Another thing to consider is communication. Litigation for many people can seem like a weird quagmire of what's going on. You have no idea what the next step is. So finding a lawyer who talks to you regularly, tells you, hey, this is what we're doing next. This is what I need from you. This is the next step. This is what the next step might cost you. This is what I recommend we do next. You want to have active communication. So finding a firm and a lawyer that actually does that actively with you, rather than you're waiting 3 or 4 months for any sort of update, is very important. Again, as a business owner, you want to know the matters being handled, and having regular updates gives you that peace of mind. So make sure a lawyer does that. In terms of some takeaways, there are ways to minimize your legal risk as a business. For the one thing, you should review your contracts regularly. Business contracts, employment contracts, all sorts of things. These do need to get updated almost every single year, almost annually. That's because the law changes and evolves. Legislation gets passed. Bill 27 came and changed non-competition agreements. Other cases like Waxdale changed what goes into a termination provision. These are recent cases that changed. We've seen employment agreements that were completely viable 2 years ago that are now unenforceable. This is the same for also your business contracts. You want to make sure your contracts are regularly reviewed. Having a lawyer go over them, very important. Same thing with staying compliant. Your policies, your business practices. The government passes new legislation regularly. Having a lawyer that constantly is got their finger to the pulse of these legislative changes so they can help you update your policies, update your agreements to make sure that you are completely in line, very important. And documentation is also very important as well. Keep records of everything you do, every contract. If you do progressive discipline for employee, keep a record of that. If you had a disagreement with an employee, with a client, you might want to keep record of that as well. How did you resolve it? What type of complaint did they make? Are they regularly complaining about the same thing? It might be important for you to be mindful of that. Furthermore, having well-drafted contracts. So I mentioned to you before that making sure your contracts are constantly reviewed is very important. They also need to be well-drafted. We recommend always having a lawyer draft any of your agreements with you. They can ensure that all the agreements are detailed and legally sound, that there's no ambiguous terms in there. A big part of the Interpretations Act, which governs the interpretation of contracts, is a principle called contra preferentum, which is a fancy lawyer Latin for whoever drafted the contract. If there's any ambiguity in it, it's read against you who drafted it. So if there's any ambiguous terms in there and you drafted the contract, it might benefit the other side to your detriment. So having a lawyer make sure there's no ambiguous terms, that there's clear and defined terms for how to deal with a disagreement, very important. Having internal compliance is also issue. This is having regular audits, reviewing your processes. This is you keeping your finger to the pulse of your own internal compliance with active legislation and laws. You can just check, make sure that your staff are actually following policies, procedures, making sure they're up to date on this legislation so they're not missing anything. And having ongoing legal counsel is crucial. Just because you have legal counsel doesn't mean that you are draining your legal fees with them. Sometimes just having a lawyer on retainer is great because you can just email them with a question, send them with something to draft and review. Having them just there to quickly get that quick on the dot legal advice, especially if you have a deadline, very important, very critical to a healthy business. Again, you want to focus on the business and pushing that forward. But it's always good to have a lawyer there to have your finger and their finger to the pulse to make sure that if something comes up, you're ready for it. Peace of mind is something you can't really put a dollar value on. And that's something that's going to keep your business healthy. Some of my final thoughts here. Litigation, although you can't prevent it, it isn't necessarily inevitable. Having these proactive measures in place, documents, compliance, audits, having all of that in place significantly reduces the likelihood of disputes. For instance, if you have a partnership dispute, but your partnership agreement actively indicates how to navigate that process, then you're not going to necessarily lead into litigation. You might go straight to arbitration or negotiation. You know how to resolve the dispute because you've got a roadmap to it. Litigation isn't inevitable. It's not unavoidable, entirely unavoidable. It could still happen. But if you've got the processes in place, you might keep your company happy and healthy. We also recommend seek legal counsel early. We've seen it many times where employers try to resolve something on their own right away and end up putting themselves in very awkward and difficult positions, such as missing defensible arguments or missing claims or missing points in their contract. Having legal advice there and in place will save you loads of headaches and costs down the road. That's something to be mindful of. Stay proactive, avoid costs. That's our thoughts there. We did get some questions submitted. I'm going to take the next 5 minutes to answer some of the questions that were sent in to us. The first question we came across is, I run a small tech company. If a big company accuses us of IP infringement, is there any way to defend ourselves without bankrupting the business? The answer is yes. This is something that a lot of small businesses, especially dealing with intellectual property or tech, have to really navigate. So the first thing you should do is consult an IP lawyer. Just because you've been accused of IP infringement doesn't mean you're actually guilty of it. There are many facts that need to be in place to actually show that you're liable of IP infringement. And if you are liable of IP infringement, again, as I mentioned before, if someone approaches you in business with a dispute, usually they have a solution in mind. That's your inroad to negotiate a settlement. And having a lawyer that negotiate and navigate that settlement could be extraordinarily beneficial to prevent the other side from actually bringing a case against you. You can discuss payment plans or other solutions, licensing fee, all sorts of ways to avoid that. Thank you for that question. One of our managers just left and took several clients with them. Is there anything we can do legally? Yes, absolutely. First thing you're going to do is review that manager's contract to see if there's a non-solicitation or a confidentiality clause in there. As I mentioned before, non-competes are kind of done away with to an extent. Sometimes if you're really high up in fiduciary, you might have an implied non-compete, but that's a whole other topic. Non-solicitation, though, those are still fine and viable. What those ones impose is that typically you're not allowed to, if you leave a company and you're a director or a manager, you can't approach your former company's clients or staff and try to poach that business away. Typically, these non-solicitations last for about 12 months, possibly longer depending on the sector. So if you have a former manager who's done this, contact a lawyer because you got to start talking solutions. Reach out to this manager. There might be a cease and desist. You might actually have to do some realistic expectations in terms of preventing them from actually engaging in business with its clients or preventing them from taking further clients from you, or restitution may be in place. How much business did you lose as a result of this manager doing it, and are they liable for paying that to you? Thank you for that question. Next one, my partner and I are disagreeing on the direction of the business and it's becoming unmanageable. How do I handle this legally without destroying our relationship? I'm going to assume that this is a partnership dispute or a shareholder disagreement. Often partnerships are formed between friends and family, and you have a business idea in mind, you trust the person you're working with, you're excited to engage in this venture together. Unfortunately, just because you get along at the start doesn't necessarily mean you're always going to get along. You will grow as a person, the business will grow, and you'll have different ideas. That's why we always recommend have contract, have an agreement in place that is separate from your friendship, from your family. Often people get in business with their family. That's all well and good, but keep the business separate. Have a shareholder agreement, have a partnership agreement, such that if there are disagreements, you have a roadmap forward of how to resolve this disagreement. It could be mediation, arbitration, it could be some sort of disagreement in terms of how to move forward, and there could be a resolution within the contract to begin with. Planning ahead for the disputes are critical to a healthy business and highly recommended. Our supplier changed the pricing unexpectedly, is now threatening to withhold supplies. Do I have any rights? Absolutely. So if you have a supplier, so this is likely a customer or client of yours, review the contract you have with them. This will hopefully have terms for what they're expected to do. What price did you originally agree to? What delivery of service did they agree to? They can't necessarily change the price on you unless the contract allows for it, or if they need to negotiate a new pricing with you. The original agreement between you and the supplier should actually detail what the solution is and what they owe to you. If there isn't one in place, definitely contact a lawyer. Look at those solutions there. There's got to be a way forward because that supplier still wants your business, but you still have a deliverable in place. I want to thank everybody for coming today. Please feel free to contact us. And as we go, I'm going to answer this last question by Mrs. Zhang. Can an employment lawyer draft a business contract? Lawyer can draft a business contract. At Achkar Law, we do have business litigators as well who draft business contracts. An employment lawyer might be more feasible to deal with employment contracts, but ask the firm. Do you have lawyers who have experience drafting? Our firm does. We can draft all sorts of contracts. Specifically ask them if they have experience in your industry and with business litigation and contract drafting. With that in mind, thank you everyone for joining us. It's been a pleasure, and I hope you have a wonderful rest of your day.